Well, Māori are renowned for speaking their minds at hui, but could your criticism land you in court? That's a situation one Māori leader is facing in an unusual legal battle. Yvonne Tahana reports.
Educationalist Susan Cullen once sang Te Wānanga o Aotearoa's praises. She's claimed Wānanga contracts earned her companies more than $70 million over 5 years. Her father, Rongo Wetere, was the CEO during the period. But now the Māori Party candidate for Hauraki Waikato is taking the tertiary institution to court. The case relates to her ultimately unsuccessful bid to represent King Tūheitia on the Wānanga's governing board. Susan Cullen alleges that in 2012, the chairman of that board, Richard Batley, defamed her at a meeting to discuss that nomination. For legal reasons, we can't yet tell you what's alleged to have been said, but Ms Cullen's not walking away from this fight.
The individual concerned made comments that defamed my reputation, and I believe that it is not a good look for that person.
Mr Batley strongly denies defaming her. He's defending the claim. It's shaping up as a test case because of a novel defence, statutory immunity.
And it provides that if you're on the council of an institution, you're not personally liable for any act which you, and an act would include a speech, if you do it in good faith and you're pursuing or intending to pursue the functions of your role in that council or that institution. And I haven't seen that defense before. It's in the Education Act. It doesn't apply generally. But I think that's a pretty powerful defense.
If people couldn't say what they needed to say in a meeting, that would be a pretty chilling thing, wouldn't it?
You should be free without worrying about getting hit in the back by a defamation suit to perform your function and say what's necessary to be heard.
The case comes at a time when the Wānanga is restructuring. Its board has 17 members, but that's set to shrink to between 8 and 12. Mr Batley declined to be interviewed, but Marae understands the board is broadly supportive of the cuts. But one board member says Māori need to outnumber Crown appointees. Equal numbers in a large Māori institution won't work.
Proportionality is important. So if we have a Wānanga of 8 council members, say, I'm not saying that's a figure, but just say we did, then half a crown for this big Māori institution, I don't think that would go down well in the Māori world.
He's less tied to a seat for King Tūheitia, but a patron role might fly.
Kings and queens come and go, but the kingitanga remains, and we have to respect that. So that's all part of the discussion. But does the kingitanga, must the kingitanga have a seat on the council? Personally, I say no, there's no need to.